Hello, my name is Joe Cordell. Welcome to another broadcast of Cash Counsel. Cash Counsel, as many of you know, is a show that's dedicated to helping guys, executives primarily, but guys who have concerns about their assets, protecting them from predators, from creditors, from any sources that might threaten them. Now, the focus of what Cordell does, of course, is in the context of divorce. So many of you already know we help men before, during, and after divorce in issues related to domestic relations. But you know, the way that this show evolved is that we recognized fairly early on that a lot of the concerns that guys have are related to protecting their assets. Now, some, of course, issues relate directly to their wife, but during the course of divorce, a lot of other concerns develop. In other words, there may be issues, litigation that comes along regarding home loans, regarding other outstanding liabilities, maybe liabilities of their soon-to-be or now ex-wife. So there's a lot of context in which asset protection issues arise in divorce. So we decided that it made sense here on Dad's Divorce to dedicate a show to discussion of those issues. So that's kind of what we hope to do here, and we hope to be relevant. We hope to give you good practical helps. Now, those of you who've been following along know that we've kind of given an overarching introduction to what is asset protection, what does it involve. We've discussed the stages of asset protection. We've discussed in very general terms of what it often involves. We've talked about the tools of asset protection. You know, those are the different means by which you might help protect yourself from creditors and predators. But now what I want to do is focus on specific tools or specific assets or aspects. And this week I kind of want to move to the discussion of entities. You know, how do you select the proper entity? Last week we talked about trusts, and trusts, we explained, are very useful in asset protection planning, and they're often used in conjunction with some of these other tools. And please keep in mind, as we go through these lists of options or means or tactics, many are used, remember, in conjunction with others. So often it's this fairly complex network of things that you'll use to protect yourself, depending on your circumstances. Choosing an entity, this is pretty basic in terms of asset protection. And matter of fact, I'll bet that many of you who are involved in some sort of business activity right now have an entity in which you work, whether it's a corporation, a partnership, a limited partnership. Many of you have recognized the importance of that sort of thing. So I'm kind of making the assumption here that many of you own a business, or you're a partner or part owner of a business. Now, what I'm about to talk about can have application to a variety of contexts. You can form these entities to manage investments. You can form them to manage side businesses. So you'll find that many of the things I'm going to talk about may apply to you even though you may have a regular job. But it's important to get this, because this is kind of the foundation of asset protection planning. And if you talk to people who know very little about this subject, then they at least get it that, oh, gee, I need a corporation because it might protect me from potential liability. So I want to talk more about the process that you go through in selecting the entity and what some of the advantages and disadvantages are in making that decision. Those of you who have already have an entity in place, many of you will understand, you know, there is an opportunity to transition to a new form, and those rules are detailed. They're going to be governed in part by the laws in your state. So obviously I suggest you do this through your attorney. But you want to think about whether it might make sense for you to have a different organizational form than the one you're presently using. So what are the options? There's the sole proprietorship. Sole proprietorship is simply doing business as yourself. And lots of small businesses do that. It's not that uncommon. A number of lawyers and other professionals might do that. So it's done. It's not recommended, and I think that it's very hard to find a justification for it. You know, what can I say in its defense? I guess I would say that it's cheap, meaning that, you know, you don't incur attorney fees, or at least not until you're sued. It's fairly easy in terms of maintaining records. Excuse me. In other words, the only return you file is going to be your 1040. So from a tax standpoint, it's simple because the IRS doesn't recognize the existence of a separate entity. No insulation from creditor claims. I think you'd understand that. It's also, I would argue that it's a hindrance in terms of maintaining the fair market value of your business. I mean, the bottom line is that if you're going to sell a business, people like to believe that they're buying some sort of discrete unit, some discrete entity. And whenever you're operating as yourself, then it tends to be construed as yourself. Now, to the extent that you're involved in a divorce, often we have clients who are in divorce, they have a sole proprietorship, it doesn't exist as an independent entity. And their argument is, look, I have a job, I'm self-employed. And there is a difference between being a business owner and being self-employed. Self-employed, as the term implies, means that you work, you do the work yourself. Unless you're doing the work, there's no value to what you do each day. So what you earn is what you obtain through your labors or your efforts on a day-by-day basis. There's not a value that exists independent of you. Another means of expressing this is saying that there's no fair market value that exists for your business if you were to try to sell it to someone else, for your activities, I should say. Now, this is often heavily litigated. It's not uncommon at all for the wife's attorney to argue that a plumber who's self-employed has a business. And sometimes that argument can fly. And certainly it's more vulnerable with businesses, or rather activities, that notoriously do have a value on the market. People who have a book of business in certain types of sales. If you're that sort of sole proprietorship, then you have much greater vulnerability in the event of divorce. Judges will often listen to what are the gross revenues of the business. They'll ask the question, what is the fair market value or the fair salary of someone who's doing that job? And if, for example, you have gross revenues on an annual basis through your activities as a salesperson of some product, and let's say that you're an independent contractor, of course. Obviously, if you're employed, then this whole discussion is moot. But if you're an independent contractor, you have a book of business, it generates revenues of $400,000 a year. If a judge could be persuaded that you could hire someone to operate that business for, say, $100,000 a year, that it has some income above and beyond simply the payment of reasonable salaries for its operation, then that has the sort of smell and the sort of taste test that would be applied to an independent business. That would suggest that also that there's a fair market value. Now, if that is an incorporated business, if it's an entity that exists in a business sense already, it may not, that in and of itself may not determine whether or not a client succeeds or fails in arguing that they do not own a business, but it certainly is a factor that a court would consider. So what do you do with this point that I just made? It would seem to argue in favor of a sole proprietorship. Well, not really. It really argues that you have to consider what the financial reality of your business is. And if the financial reality is that you're generating revenues that would suggest that an independent business exists, that you could hire employees to operate in your absence, that you could be paid a reasonable salary and then have additional income, which would be considered profit, that people looking at your industry can find where transactions have occurred of a business similar to yours, or rather an activity similar to yours. If that evidence can be presented by the wife's attorney, by your wife's attorney, then it's going to be pretty persuasive that a business exists. But I will say this: when you're operating as a sole proprietorship, it at least is consistent with your argument that you're simply self-employed, that there is no business that exists distinctly of your activities, if that makes sense. Now, having said that, I still would argue, though, that the bottom line is you have to think about the bigger picture. And should that factor in and of itself argue that you should be a sole proprietorship when you're on the threshold of divorce? I don't think so. I don't think so. I think that you're going to live or die, you're going to succeed or fail by the financial realities of your business, your financial statements and other things, the characteristics of your industry, similar sales, etc. Those are really more likely to be influential in the decision of the court than this one factor I mentioned. But I did want to deviate there to discuss sole proprietorships and how they're weighed and other factors are weighed in the context of divorce. I guess continuity of existence is another important consideration to people who engage in a business, and it's much more difficult, obviously, if you have a sole proprietorship. If you die, then there's a lot of confusion about what you do or how it's transferred upon your death. So issues about succession, business succession, are huge when you're considering the continuity of a sole proprietorship. So if continuity of your business, transferability, those issues are important, then you need to think about some sort of corporate or business form.